Good morning, everybody. Good morning. Today is the first day of hearings in our London venue, Arundel House. As things stand, we have a further 6 public hearings scheduled over the next 18 months, the majority of which will take place in this building. The Lampard Inquiry is breaking new ground, as it's the first UK public inquiry to investigate mental health care. Throughout the upcoming public hearings, we shall listen to, examine, and challenge evidence that goes to the heart of the issues of this inquiry. I've promised that those who have suffered loss and those who have sadly died will always be at the heart of this inquiry. This remains my firm commitment. It's crucial that we keep in our minds the people who experienced, either directly or indirectly, the mental health inpatient services with which we are concerned. I know that engaging with the inquiry can, for some people, be difficult and upsetting, as it focuses on an incredibly challenging time in their lives. I wish to remind everyone that emotional support services overseen by the inquiry's chief psychologist are available. Anyone who needs assistance during the hearing should please contact my inquiry team, who will help them to access this support. I remain grateful to all those who offer to meet with me or my team, or offer to contribute information or evidence, or otherwise support the work of the inquiry. This includes all those who provided commemorative evidence to the inquiry last year. Since the start of this year, I've had the benefit of attending 23 introductory meetings with family members who are also core participants, some of whom I can see in the room here today. I wish to thank those who attended, as I gained much from these meetings and from hearing their reflections on the inquiry to date and the aspirations that we have for it. Where possible, I and my inquiry team have acted quickly to address issues raised, like making available more information about the inquiry's process, including publishing further detail on future hearings, and how the inquiry plans to request information from those involved with our work. As we proceed, we will continue to listen, learn, and where appropriate, adapt. Some reflections from those meetings are harder to address universally. One matter raised was the way in which the inquiry will investigate and examine the issues, and especially the level of investigation that individual cases will receive from the inquiry. I'll go on now to say more on both of these points. I recognise that the ambitions and expectations for this inquiry are different for different people, depending on their past experience and how they have come to be involved in the inquiry. Some people may feel that the inquiry will wander away from where they had hoped it would go. So I wish to be clear now on the path the inquiry will take. The inquiry's focus is on systemic issues relating to mental health inpatient care in Essex. We are investigating the big critical concerns about what went wrong that span across over almost a quarter of a century. The inquiry will dive down into these systemic issues with increasing focus and detail until we have enough evidence, information, and understanding to satisfy ourselves about what really happened and why, so that I can report my findings and make meaningful recommendations for change. To help me and my team to focus on the systemic issues central to this inquiry, we published in February a revised list of issues. This list of issues will help guide our investigative work. We sought engagement on it from interested people and those with clinical expertise to ensure that it covers the issues most relevant to our inquiry. The list of issues may evolve alongside our investigations, with issues added, removed, or amended to reflect what the inquiry is hearing and thinking. We will seek out the truth. In doing so, we will not simply accept the information we're given, but instead will question and challenge the evidence until we're satisfied that the findings we make are the truth or as close to the truth as we can come. In order to support me in understanding the complex and wide-ranging issues being considered within this inquiry, I've recently appointed 3 independent assessors and 3 experts. These are highly skilled individuals with knowledge and experience within their respective areas of mental health care and data analysis. They will support me and my inquiry team to understand and analyse important aspects of our work. Counsel to the inquiry, Nicholas Griffin KC, will tell you more about these individuals and the role they will take in the inquiry when he speaks shortly. To further support our understanding, earlier this month, the inquiry made available on its website 2 important background presentations, one produced by the King's Fund and another by the National Collaborating Centre for Mental Health. These presentations, which are delivered as video lectures with supporting materials and documents, provide background information on mental health inpatient care. The topics covered by these seminars include the legislative and policy background and guidelines for good medical practice in the delivery of mental health services nationally over the 24-year period the inquiry is concerned with. The presentations were produced to help me and every person involved in or following the inquiry's work to better understand the background and the expected mental health care for mental health inpatients over the 24 years in scope. For anyone who's not seen these presentations, I do recommend watching them. This leads me on to the purpose of these hearings, which to begin today and end on the 15th of May. We shall start by hearing an opening statement for counsel to the inquiry, Nicholas Griffin, KC. We shall then hear evidence which gives important contextual background on mental health inpatient care in Essex. We'll hear from medical experts, healthcare providers, and other relevant organisations on topics such as what good mental health care should have been at various points over the 24-year period in scope, aspects of the setup and organisation of mental health care in Essex, and evidence on some of the key issues, including ligatures and absconsion, the use of technology, such as Oxyvision, and finally related investigation processes, such as health and safety executive prosecutions and inquests. This is the start of us exploring the background and context to our inquiry, a process that will examine matters with greater specificity over the next 18 months of hearings. I'm conscious that some core participants may not have had the time wanted to formulate their views on some of the matters raised in this hearing. but they will have the opportunity to present further evidence on the matters raised as the inquiry proceeds. The reason we're starting with contextual background is that it will assist me and my inquiry team to better understand the material and evidence we will receive on what went wrong. This includes better understanding the important issues within individual cases, which we will be investigating and hearing evidence on in our July hearings and at future hearings thereafter. As I stated in my first opening statement in September last year, I'm not going to be opening up and determining cause of death in every single case. This inquiry cannot rerun the inquest process or conduct forensic police-style investigations. We will investigate the issues raised by individual cases to the extent necessary to fulfill the terms of reference. The cases that the inquiry will review will be those that allow us to explore the broad range of themes and will be illustrative of the issues that have arisen over the 24 years and that fall within the inquiry's scope. For this reason, we will refer to them as illustrative cases. All bereaved families who are core participants will have their illustrative cases reviewed by the inquiry to the extent that I conclude is necessary in each case. But these are by no means the only cases that the inquiry will consider. There will be other cases, other than core participant family cases, that will be reviewed in more detail by the inquiry. These include, to give just one example, deaths occurring under the care of child and adolescent mental health services, or CAMS. The nature and extent of the investigations into the illustrative cases will depend on the circumstance of each case being reviewed. Investigations will be carefully adapted to the circumstances and requirements of each illustrative case. I can assure you that my legal and counsel teams who will be carrying out the investigations are highly skilled with many collective years of experience of leading investigations in public inquiries, inquests, and examining deaths which have taken place within healthcare settings. And they will, of course, be ably supported by the inquiry's clinical assessors and experts. This will be an evolving picture. The inquiry will keep its approach to illustrative cases under review at all times as our investigations develop and we receive more evidence. At future hearings, the inquiry will also explore evidence on relevant themes and issues, some of which are likely to evoke strong opinions and give rise to conflicting viewpoints. For example, in future, the inquiry is minded to hear evidence on the preventability of suicide and whether suicide should be considered theoretically preventable in each and every case. The concept of compassion fatigue in those working in mental health care, which is where the prolonged exposure to the suffering of others leads to a decline in empathy and compassion. The circumstances where it is and where it is not appropriate to detain someone under the Mental Health Act. The balance to be struck in mental health care and treatment between risk management and therapy. I understand these will be difficult discussions, but an inquiry of this scope and importance cannot do anything but confront head-on these big and difficult questions. There will be topics that this inquiry covers that will be challenging for some people to listen to, which is why I wanted to acknowledge that now from the very start of these evidential hearings. The inquiry is an investigative process, not adversarial. It's a process in which we seek to gather the best evidence we can. To achieve this, the inquiry considers it important that it hears a diverse range of perspectives on the issues that matter most. The inquiry values all voices, including, of course, those of bereaved families, those with lived experience, also mental health staff, campaign groups, and the senior leadership within key organisations. We must ensure a balanced and comprehensive understanding of mental health inpatient care. We're independent from all those engaging with the inquiry and from government. We shall decide for ourselves what good mental health inpatient care should look like, where things went wrong, and where things went right. We will question statements and assumptions about care and treatment from wherever they have come. There may be things said during hearings that some people disagree with, potentially very strongly. In order for the inquiry to obtain the best information and evidence possible, everyone speaking at these hearings must be given the opportunity to be heard. Everyone attending or engaged in these hearings must be afforded respect throughout. I therefore ask that those attending listen quietly and respect quietly to the evidence being given, and that there are no disruptions, shouting out, or disturbances of any kind. As I have outlined, I wish to hear a diverse range of views. We're dealing with the most sensitive of subjects, and it's understandably distressing to many. I request that everyone is treated with courtesy at all times. To do our work properly, the inquiry relies heavily on the cooperation of those engaging with it. My intention is, whenever possible, to work collaboratively with core participants and others to achieve the inquiry's objectives. I'm grateful to all those who have provided, in a timely way, material to the inquiry so far. I appreciate the resource and effort that required. Let me be clear that I expect the inquiry's requests for evidence to be met promptly and with complete candour. I will not hesitate to use my statutory powers to the fullest extent necessary to compel the production of evidence where it's not provided or not provided promptly. This does not and will not apply to families of those who died and those with lived experience, who will be able to choose whether to respond to any request from the inquiry to provide evidence or information, and my inquiry will work with them on how this can be done. I will not compel family members or those with lived experience to produce evidence or require them to speak at a hearing if they do not wish to do so. I turn now to the final point that I will cover today, which is the outcome to be achieved from this inquiry. As I've said previously, following my thorough investigations of the issues in scope, I will set out in a report the key factual background, the key evidence, and my analysis of it, my findings and recommendations. The inquiry is investigating what occurred under the care of Essex NHS mental health trusts. Although the focus is on Essex, the inquiry is of national significance, and wherever possible, my ambition is to make lasting, positive recommendations to improve mental health care right across the country. The time frame the inquiry is investigating covers, as I've said, nearly a quarter of a century. That is 24 years during which the policy landscape and expectations of good mental health care would have been changing and developing. Recent national developments in mental health legislation and policy indicate that significant changes will continue throughout the time of our inquiry. We will need to ensure that any recommendations based on findings from historic matters are still relevant at the time our inquiry concludes. But from what I already know, there are many matters identified that remain of current concern. To support the work of making recommendations as effective as possible, the inquiry will be establishing a recommendations and implementation forum. Counsel to the inquiry, Nicholas Griffin KC, will say more about this forum shortly. As the House of Lords Statutory Inquiries Committee stated in their September 2024 report, inquiries have a core purpose: to publish recommendations for change so as to prevent the recurrence of an event of public concern. I remain continuously mindful of this core purpose and of the need to make impactful recommendations for change. I would like those who experience mental health inpatient care to have confidence in the system, confidence that they will receive appropriate and therapeutic care, confidence that they will be treated with empathy and respect, and that they will be safe. That was not always the case in Essex. Today is the start of what I hope will be an informative and insightful hearing, which will form part of the groundwork for the inquiry's investigations. I wish to thank all those who have been involved in getting us to this stage of the inquiry. This has required an extraordinary amount of work from core participants, legal representatives, witnesses, experts, and my dedicated inquiry team. I'm immensely grateful to everyone. I'll now hand over to counsel to the inquiry, Nicholas Griffin.
Thank you, Chair. In fact, what we'll do now is take a break. I will suggest that we start again at 11:15, so that gives people just over half an hour. So back here, starting at 11:15, please.
Mr. Griffin.
Thank you, Chair. May I just check that everyone can hear me okay? Thank you very much. In September and November last year, the inquiry heard important commemorative and impact evidence from those whose family members and close friends had died as mental health inpatients or otherwise in circumstances that we are investigating. It was compelling. We also received opening statements made on behalf of the core participants, which the inquiry has found very helpful. We now reach the stage in the inquiry where we start to hear evidence of a different kind. we will be hearing evidence that relates directly to the inquiry's terms of reference. As this is the first stage of that evidence, it will be largely by way of introduction. In this opening statement, I will be touching on some of the points that you raised just now, Chair. Where I do, my intention is not to cover the same ground, but to provide some further detail. Both in this opening statement and throughout the next 3 weeks of hearings, the inquiry will be talking to and discussing content that will be distressing and difficult to hear. While this hearing will generally not go into detail about individual deaths or experiences, the themes that we are discussing may be deeply painful, as they relate to the trauma, grief, and loss suffered by many who are here today or watching online. At the start of each day and evidence session, I will clearly set out the topics that will be covered to give those attending, watching, and listening the opportunity to decide whether or not they wish to, or indeed are able to, engage with those topics. The timetable for this hearing is also available on the inquiry website, with information about the topics that will be discussed during each evidence session. In this opening statement, I will be touching on topics such as ligatures, absconsions, the use of restraint, HSE prosecutions, the Parliamentary and Health Service Ombudsman, healthcare regulators, inquests, inpatient care, inpatient facilities, Oxyvision, investigations by the Health Services Safety Investigations Body, and recent deaths. I'd like to be clear that anyone in this hearing room is welcome to leave at any point. As I've said, people attending or watching remotely may find some of the matters I am going to talk about and that we hear evidence about distressing. Before I go any further, I'd like to make clear, as you have, Chair, that emotional support is available for all those who require it. The well-being of those participating in the inquiry is extremely important to the inquiry. We have 2 support staff from Hestia, Naveed and Lorna, an experienced provider of emotional support, here today and for each day of this hearing. I'm just going to ask Naveed and Lorna to raise their hands to identify themselves to you. You'll see that they're wearing orange lanyards. There's a private room downstairs where you can talk to Hestia support staff if you require emotional support at all throughout this hearing. You'll see, as I've said already, orange lanyards they're wearing, and I understand also orange scarves. Thank you. Or you can speak to a member of the inquiry team, and we can put you in touch with them. We're wearing purple-coloured lanyards. If you're watching online, information about available emotional support can be found on the Lampard Inquiry website. That's lampardinquiry.org.uk, and it's under the Support tab near the top right-hand corner. You can also contact the inquiry team's mailbox on contact@lampardinquiry.org.uk for this information. We want all those engaging with the inquiry to feel safe and supported. The role and remit of the inquiry is to investigate mental health in patients' deaths. It is not the role of the inquiry to intervene in clinical decisions for current patients or to act as a regulator or in the role of the police. However, the inquiry has a safeguarding policy and takes safeguarding matters seriously. Where we receive any information which meets our safeguarding threshold, we will pass it on to the appropriate organisation. This is something which has been done since the inquiry was established and which we will continue to do. I am assisted at this hearing by members of the Council Inquiry team, Rebecca Harris, King's Counsel, and Rachel Troop, and I'm joined today by Kirsty Lee. Further members of the CTI team will be involved during the course of the hearing, and I will introduce them at the relevant time. I'm grateful for all of their help. The council team works closely with the Lampard Inquiry solicitor team under Catherine Turtle. The inquiry would not be able to operate without them. We also rely heavily on the work of the professional and experienced secretariat team and the inquiry's engagement team, who are part of the secretariat and with whom many of those engaging with the inquiry have been in contact. I want to be clear that my colleagues and I have been instructed by you, Chair, to assist you in your important task. We are part of the inquiry team working for you. We are independent from all other organisations and individuals involved in this inquiry. I'd like now to introduce the lawyers who are representing core participants. For the bereaved families and those with lived experience, Bates Wells, Bat Murphy and their counsel, Fiona Murphy, King's Counsel, Sophie Miles and Lily Lewis. Bindmans LLP and their counsel, Brenda Campbell, King's Counsel. Hodge, Jones and Allen and their counsel, Stephen Snowden, King's Counsel. A.K. Burren, Jake Looms, Rebecca Henshaw-Keane, Irwin Mitchell, LLP, Lee Day and their counsel, Maya Sikand, King's Counsel. Several families are also assisted by counsel Laura Profumo and Tom Stote. For the organisations, for Inquest, Bat Murphy and their counsel, Anna Morris, King's Counsel, and Lily Lewis. NHS England are represented by DAC Beechcroft, LLP, Jason Beer, King's Counsel, and Amy Clark. The Department of Health and Social Care, represented by the Government Legal Department, Anne Studd, King's Counsel, and Robert Cohen. The Care Quality Commission are represented by Counsel Jenny Richards, King's Counsel, and Rachel Sullivan. North East London NHS Foundation Trust by Kennedys and their counsel Valerie Charbit. Essex Partnership University NHS Foundation Trust are represented by Brown Jacobson LLP and their counsel Eleanor Gray, King's Counsel, and Adam Fullwood. The Integrated Care Boards by Mills and Reeve and their counsel Kate Brunner, King's Counsel, and Zinat Islam. Oxy Health by Bevan Britton and Fiona Scolding, King's Counsel, and Stop Oxyvision by Bindmans and Brenda Campbell, King's Counsel. I'm grateful for their engagement and input in the run-up to this hearing. In this opening statement, I intend to cover a number of different areas. First, I'd like to report on progress made by the inquiry since our last hearing in November. Then I intend to look at different aspects of the evidence the inquiry is receiving or intends to receive. I'll next move on to this hearing, look at various preliminary matters, and then provide an introduction to the evidence that will be presented over the course of the next few weeks. And finally, I will consider two important matters. The first is the changing landscape into which you will be delivering your report and recommendations, Chair. And the second is what recent inquests and deaths may reveal about the extent to which the issues in Essex are really being addressed. Starting then with progress since November. The inquiry has been busy since our last hearing in November. Its work has advanced in a number of significant ways. Chair, you have already mentioned the importance of the meetings you've had since the start of this year with core participant family members. As we will see, the inquiry has been listening to its core participants and others, and to members and to the matters raised in opening statements last year and other interactions with the inquiry. We have accepted the force of many matters raised and, where appropriate, tailored our work and investigations accordingly. Although this is, of course, an independent inquiry, we have considered with care the issues that will be of importance to the family members and close friends of those who died. We have sought to ensure that at least some of these issues will be considered in this hearing by way of introduction. Turning to the list of issues, as you mentioned, Chair, it has been created to provide a more detailed approach to the investigation of issues raised by the inquiry's terms of reference. I discussed the terms of reference in some detail in my opening statement back at the start of the September hearing. The inquiry published its provisional list of issues in July last year and invited feedback and suggested amendments prior to the revised list of issues being published on the 20th of February this year. A huge amount of work has gone into the revision of the list of issues, and the inquiry is grateful to everyone who has engaged with us and suggested amendments by whatever means. Core participants provided considered and helpful submissions about the provisional list. These were taken into account and, where appropriate, incorporated into the revised list. Likewise, the inquiry considered all points that were raised more generally in written and oral opening statements submitted to the inquiry by core participants during the course of its September and November 2024 hearings. As the introduction to the list of issues makes clear, it will be a matter for you, Chair, to determine the nature and extent to which any of the issues may be investigated in order to meet the inquiry's terms of reference. The inquiry is not necessarily required to investigate all of these numerous issues in depth. Further, there may be issues which, due to the passage of time or lack of available evidence, cannot be addressed fully or in part. The list of issues provides a helpfully detailed delineation of the issues to be considered. It may, if necessary, evolve as the inquiry receives evidence and undertakes its investigations. Now, Chair, I'm going to ask that the first of a number of documents are put up on our screen. So I'll ask our evidence handler, Amanda, to put up the list of issues and go to the bottom of the second page, please. We can see here, by way of example, part of the list of issues, and I want to just look at it to get an idea of the way it works. We can see here the start of the section addressing the assessment process. It asks a series of questions. How were individuals assessed for mental health inpatient admission, and what clinical processes and procedures applied during the relevant period? Specifically, who could request or refer patients for such assessments? How and to whom could a referral be made? What criteria applied, and did these change over time? Would you go to the top of the next page, please? Thank you. How easily could an assessment be arranged? What factors affected when an assessment could take place? Who carried out assessments for admission, and where were they undertaken? Who was consulted during the course of any assessment, and who was notified as to the outcome? The section then goes on to ask further questions on the same theme, and in this way we hope and expect that the list of issues here and in its other sections will be a useful tool to help guide the inquiry's investigative work. Thank you. Could you take that down, please? Turning now to position statements, which may provide the inquiry with a better early understanding of the role played by particular organisations. They may help it to crystallise issues, focus on key areas, and understand those areas in which it's accepted that standards fell below what was acceptable, or conversely, which provide examples of good practice. The written opening statement of the families represented by Bindmans LLP, provided for the purposes of the November hearing, and the further submissions made at that hearing by Brenda Campbell, King's Counsel, urged the inquiry to seek position statements. The inquiry considered these submissions and requested position statements from Essex Partnership University NHS Foundation Trust, which I'll refer to as EPUT, and the North East London NHS Foundation Trust, or NELFT. This was because of their direct role in the provision of inpatient mental health care in Essex during the relevant period. The inquiry is likely to seek further position statements from other relevant bodies. The inquiry has circulated the EPUT position statement to core participants, and it will be available on the inquiry's website. We will be calling EPUT's CEO, Paul Scott, to give evidence at the end of this hearing The questions he will be asked will be addressed at, and limited at this stage to, issues arising from the position statement. We will ask him to come back to give evidence on more detailed matters at a later stage. More generally, and not limited to position statements, the inquiry should not need to remind providers that every health and care professional is subject to the duty of candour. They must be open and honest about what has gone wrong with treatment and fully cooperate during reviews and investigations such as this inquiry. Chair, you've already spoken today about the outcome to be achieved by this inquiry and the importance of the recommendations you'll make. As you will recall, several of the core participant opening statements at earlier hearings also referred to the importance of recommendations. They referred specifically to the requirement that these recommendations must be implemented by the relevant government, health or other body if meaningful change is to be made. As I noted at the November hearing, whilst it's currently too early to be considering the content of any recommendations you may make now is the right time to be considering their implementation. In other words, what can be done to ensure that your recommendations, when made, are clear, focused, in an implementable format, and that they are then implemented by the responsible body? We will expect those within these responsible bodies to be preparing for their speedy implementation from an early stage. I'm therefore pleased to note that the position statement provided on behalf of EPUT makes clear that it is committed to learning from the inquiry and ready to implement recommendations arising from the inquiry which are in our control. There is also the connected issue of the extent to which the implementation of recommendations can and should be monitored, and if so, how. Chair, you directed that a Lampard Inquiry recommendations forum should be set up. That process has started. We're now referring to it as the Recommendations and Implementation Forum to reflect the importance that issued recommendations are indeed accepted and implemented. I'm pleased to say that the inquiry has secured the assistance of a noted academic with expertise in public inquiries for the forum. She is Dr. Emma Ireton, Associate Professor at Nottingham Law School. She specialises in research in applied public inquiry law and procedure. She's co-author of a book about public inquiries, and she will assist the forum by providing a report covering relevant issues connected to recommendations, their acceptance and implementation, and the ways in which implementation might be monitored. We will circulate her report along with a paper from the Council to the Inquiry team, which includes our suggestions for how the forum should work. We will then seek the views of core participants and other key stakeholders about the best way forward for the forum. We have our eye firmly on the recommendations you may make, Chair. We would expect that the forum's work will increase the likelihood of government and health bodies accepting and implementing recommendations. I want to return to talk about the forum a little more later on. This will be when I consider some significant recent developments that are likely to be highly relevant to the context into which recommendations will ultimately be delivered. Chair, you mentioned back in September that the inquiry has carefully considered the language we plan to use in connection with mental ill health and other matters the inquiry is considering. We've set out our approach to terminology in our Lampard Inquiry Terminology and Glossary. It is a publicly available document via our website. The language set out in the terminology section of the document is not mandatory, as those involved with the inquiry are free to express themselves as they choose, provided it is respectful. However, it's helpful to have a reference document explaining the terms the inquiry will be adopting We've kept this document under review, and it has recently been updated to include a glossary section covering mental health conditions and symptoms, mental health professionals, teams and types of units, and mental health treatments. It also includes a list of acronyms commonly used by the inquiry and in the evidence we will be hearing shortly. This is to help people following the inquiry to understand words that may be less familiar to those outside the medical profession. As we have previously said, we would be happy to engage with core participants and others who have suggestions for the development of this document. Chair, at the conclusion of the November hearing, you indicated that you had asked the inquiry team to consider how to gather together all of the commemorative and impact evidence and present it in a way that preserves and reflects their vital importance to the inquiry's work. You've mentioned again this morning the importance of this. Following feedback from those who provided the evidence, the inquiry will be creating a dedicated page on our website, which contains much of the commemorative and impact evidence shared with us. The inquiry will liaise with those who provided accounts to determine what they would like to be shared on the website. The inquiry intends to create a further piece that reflects the voices and experiences of those impacted by this inquiry. This will include honouring the important contributions that were shared during the commemorative and impact hearing, as well as any future such evidence. We remain extremely grateful to all of those who felt able to provide the personal and moving accounts in relation to their family member or friend. And Chair, as you said in November, they are vital to the work of this inquiry. Chair, you have referred to the appointment of the inquiry's independent assessors and experts. Section 11 of the Inquiries Act 2005 gives you the power to appoint assessors to assist the inquiry. Before such an appointment, you must be satisfied that the person you propose to appoint has the knowledge and experience which makes them a suitable person to provide assistance to the inquiry. Following a rigorous selection process which included liaison with core participants, the inquiry has appointed 3 independent assessors. We are very pleased to have secured their assistance. They are all experts in their respective areas of mental health provision and will inform the inquiry on important clinical aspects of its work. The appointed assessors occupy a range of clinical posts and come with considerable experience of providing frontline mental health care. They've been in post since the 5th of February this year, and they are Dr. Nicola Gota. Dr. Gota has worked as a consultant psychiatrist for over 20 years in areas including crisis, inpatient, intensive care, assessment, and community teams. She has significant experience in crisis teams, establishing a team in 2003 and working on key research in the area. She is currently the responsible officer for West London NHS Trust and worked clinically in early intervention in psychosis, as well as acute psychiatry. Dr. Gota has worked as a locality clinical lead, clinical and educational supervisor, and clinical director. From 2019 to 2024, she was the Trust's Deputy Chief Medical Officer and Caldecott Guardian, as well as Chair of the Trust's Mortality Review and Medicines Optimisation Groups. She acted as Chief Medical Officer for the Trust in 2020-21. Mick O'Driscoll, MBE. Mr. O'Driscoll is a retired, registered mental health nurse with 30 years' experience of working in both junior and senior clinical roles within NHS acute adult mental health services. His various job roles as a staff nurse, matron, clinical nurse specialist, associate director of nursing, and clinical director kept him close to the clinical area he most enjoyed, acute inpatient wards. He also developed and led the training of many nursing, medical, and occupational therapy staff in his area of specialist interest, understanding suicidal behaviour and risk. In 2014, he was awarded an MBE for services to mental health nursing. Dr. Elizabeth Walker. Dr. Walker qualified as a doctor at St George's Hospital Medical School in 1995 and has worked as a psychiatrist since 1997. She's been a general adult consultant psychiatrist working in the northwest of England for the last 15 years. Her area of expertise is in continuity of care, having been responsible for the care of her patients through both community and hospital settings. She also plays an active role in medical education, for example, training students and junior and senior doctors, and in management. The assessor's roles include, but are not limited to, offering general advice and explanation on any specific issue on which they have appropriate knowledge and experience, and in particular the clinical aspects of the inquiry's work, advising on potential avenues of the inquiry, and providing you, Chair, with any other assistance or advice on any matter relevant to the inquiry within the knowledge and experience of the assessor. Assessors may be appointed from a range of disciplines relevant to the inquiry's focus, not limited to clinical experience and knowledge. This allows flexibility in addressing various aspects of the inquiry as needed. Chair, you are keeping an open mind about the appointment of further assessors as appropriate. Further information about the appointment and role of the inquiry's assessors can be found on the inquiry's website, and there is also a protocol on the role and appointment of assessors. Assessors assist the inquiry in the ways I have outlined, but they are not witnesses and they do not give evidence on which you, Chair, will rely for the purpose of reaching conclusions or issuing recommendations. Where you wish to consider in detail any specific issue, including standards of clinical care and the nature and extent of any failings, you will consider instruction of an appropriate expert witness who is able to provide a written report or reports and oral evidence at a hearing. This will form an important part of the body of evidence that you will be considering. To date, you have appointed 4 expert witnesses. They are Professor Crystal Donnelly, CBE. The inquiry has recognised from an early stage the importance of the data it will capture from the trusts and others. Data has the potential to provide insight, to reveal trends, and to expose further areas of concern. The inquiry also recognised the need to instruct an expert statistician of appropriate standing and experience to assist it with its work. We are therefore very pleased that Professor Donnelly has agreed to act as expert health statistician to the inquiry. Her role is to provide expert advice and opinion in the field of health statistics and to support the inquiry with data analysis. Although at an early stage, she's working to identify and analyse relevant data in order to assist the inquiry in drawing relevant conclusions as to deaths within scope. Insofar as possible, she will be seeking to place these within the proper national context. The extent to which the available data will allow such conclusions remains to be seen. Professor Donnelly is head of the Department of Statistics at the University of Oxford and formerly Deputy Director of the World Health Organization Collaborating Centre for Infectious Disease Modelling at Imperial College, London. She recently completed her 4-year term as Vice President for External Affairs of the Royal Statistical Society. She was a senior member of the Imperial College COVID-19 response team, whose work informed government policy in both the UK and internationally. She also served as a member of the expert group on statistics for the infected blood inquiry. She's a fellow of the Royal Society and of the Academy of Medical Sciences. She was awarded a CBE in 2017 for services to epidemiology and the control of infectious diseases. She's being supported in her work by Dr. Maria Christodoulou. Dr. Christodoulou is a senior statistical consultant, a chartered statistician, and former postdoctoral researcher in biostatistics at the University of Oxford. She is an expert in both quantitative and evolutionary biology, with specialised knowledge and expertise in the handling of large longitudinal data. Professor Donnelly's evidence will be of central importance to the inquiry, and we look forward to receiving reports from her. Dr. Ian Davidson. Dr. Davidson is a consultant psychiatrist. He will be giving evidence at this hearing, which I will be discussing later. He has extensive experience in both inpatient and community general psychiatry. He formerly held different roles at Cheshire and Wirral Partnership NHS Foundation Trust as consultant general adult psychiatrist, medical director, deputy chief executive, and interim chief executive. Dr. Davidson's roles at the Royal College of Psychiatrists included as clinical lead during Lord Darzai's investigation into the NHS in England and as inaugural autism champion between 2017 and 2021. He's currently national clinical lead in the Getting It Right First Time programme for the crisis, acute adult and older adult mental health community and acute inpatient services. Getting It Right First Time is a national NHS England programme designed to improve the treatment and care of patients through in-depth review of services, benchmarking, and presenting a data-driven evidence base to support change. Maria Nelligan. Miss Nelligan has been instructed to act as a mental health nursing expert. She's drafted a report that is complementary to that of Dr. Davidson, and her evidence, together with his, will form part of this hearing. Miss Nelligan is an experienced registered nurse who first began practicing in mental health in 1985. She has held significant roles, including as chief nurse and quality officer at Lancashire and South Cumbria Foundation Trust, and as Director of Nursing and Quality at North Staffordshire Combined Healthcare NHS Trust. Her further roles included as Associate Deputy Director of Nursing, Mental Health, at Cheshire and Wirral Partnership NHS Foundation Trust, and secondment to Greater Manchester Mental Health Trust to support them particularly in patient safety and experience. During the relevant period, Miss Nelligan has gained substantial experience in external roles, providing independent assessment of nursing standards in mental health inpatient care. She's also contributed to setting national standards of care in mental health inpatient care, including most recently working on NHS England's 2024 guidance, Culture of Care Standards for Mental Health Inpatient Services. And the fourth expert instructed is Dr. Emma Ireton, to whom I've already referred. It's clear that further experts covering different fields will need to be instructed as the inquiry proceeds. Chair, the inquiry will keep this under review. I turn now to the two presentations that have been commissioned by the inquiry and provided in preparation for this hearing. You have already referred to them, Chair. They present vital background information and set the scene for the evidence that is to follow. These pre-recorded presentations were made available online on the 14th of April via the inquiry's website. They are by way of introduction. They do not claim to cover everything. We believe they cover ground that is not controversial, but if there is anything in them with which core participants and key stakeholders disagree, they should let us know. It will then be investigated as appropriate and consistently with our terms of reference and list of issues. The first presentation has been provided by the King's Fund's Helen Gilbert, who has been supported by a team from that organisation. Ms. Gilbert is a fellow in their policy team with over 20 years' experience in delivering research, analysis, advice and information related to mental health care policy. the King's Fund is a well-established and independent charity which works to improve health and care in England and delivers education relating to the health service in the United Kingdom. This presentation addresses the national legislative and regulatory landscape for the provision of NHS mental health inpatient care during the relevant period. The aim of the presentation is to provide an explanatory overview of the relevant NHS structures, regulatory bodies, legislative provisions, key national policies and guidelines which underpin the provision of inpatient mental health care nationally. Evidence relating to local services within Essex will be heard separately during this hearing, as I'll come on to explain. The presentation is accompanied by helpful materials, and I will be looking at a couple of the slides provided with the presentation later on by way of example. The National Collaborating Centre for Mental Health has provided the second presentation. That is a partnership between the Royal College of Psychiatrists and University College London. This presentation is given by consultant psychiatrists, Professors Stephen Pilling and Tim Kendall. It identifies and explains the relevant guidelines from the National Institute for Health and Care Excellence, or NICE, in respect of the provision of care to mental health inpatients during the relevant period. It includes an explanation of NICE guidelines more broadly, their development and substantial changes to them during the relevant period, and other key associated national care standards. Chair, moving now to the appointment of some new core participants. Last month, the inquiry contacted 6 organisations, inviting them to apply for core participant status in the Lampard Inquiry. These were 3 private providers of mental health inpatient care, 2 police forces, and a provider of digital monitoring technologies. None had applied during the original application window last year. Chair, the decision to grant core participant status is entirely at your discretion. The process for applying is one I addressed in September and which can also be found in the inquiry's core participant protocol. The decision to apply is a matter for the individual organisations. There is no obligation to do so, nor does the inquiry have a power to require it. It is possible to engage with the inquiry as a witness or a material provider who may provide documents or other information without being a core participant. But there were specific reasons why you, Chair, believed it was appropriate for these organisations to consider applying, as I will outline, and why in their cases core participant status would allow them to engage fully in the inquiry's process. Dealing with those organisations in turn: Signet Health and Priory Group. The inquiry believes that the roles of Signet Health and Priory Group as key providers of mental health inpatient care in Essex, with multiple facilities across the UK, position these organisations as important participants in understanding the issues of patient safety, treatment, and care in mental health inpatient settings. The inquiry further believes that their insights into the functioning, monitoring, and practices within these environments are crucial. Both were invited to apply to become core participants. Signet Health have now applied for and been granted core participant status. Priory Group have declined the inquiry's invitation to apply. St Andrew's Healthcare. In their opening statement provided to the inquiry in November last year, the lawyers representing the family of a former patient of St Andrew's Healthcare raised concerns with the inquiry about the care that was provided to her. It would appear, therefore, that serious concerns exist regarding the care, treatment, and safety of patients within St Andrew's healthcare facilities. This points to the importance of St Andrew's involvement in the inquiry to help shed light on the systemic factors that may have contributed to failures. St Andrew's Healthcare was invited to become a core participant and has indicated that it intends to apply for core participant status by the end of this month. Essex Police and British Transport Police. These forces had roles both investigating and responding to incidents and allegations of criminal activity within mental health inpatient settings in Essex and in relevant places outside Essex. They were part of interagency collaboration with health authorities and other stakeholders. This makes them important contributors to understanding the broader context of patient safety in mental health inpatient settings. Both were invited to apply to become core participants. The Chief Constable of Essex Police made an application and has now been granted core participant status on behalf of that force. And British Transport Police have indicated that they will be making an application. OxyHealth Limited. The use of digital monitoring technologies in mental health settings, including Oxyvision, has been the subject of considerable discussion and scrutiny in recent years. As a provider of such technology to ePut, the inquiry believes that OxyHealth, the company behind Oxyvision, is well placed to contribute valuable insights into its development, implementation, and impact on patient safety and well-being. Indeed, we will be hearing from an OxyHealth witness at this hearing, as I will come on to explain. OxyHealth was invited to apply to become a core participant. It responded by making an application, which has been granted, and they are now a core participant to the inquiry. Chair, I turn now to the issue of undertakings. The inquiry wishes to use all possible means to ensure that important evidence is received and heard. Where necessary, it will deploy its statutory powers to compel evidence. But that can only apply when the inquiry is aware that the evidence exists. In addition, the inquiry wishes to take all appropriate steps to encourage people to come forward with relevant evidence that it does not yet know about. The inquiry therefore considered it necessary to seek limited undertakings from the relevant providers and healthcare regulators that were designed to facilitate the flow of that potentially important evidence to the inquiry. Chair, you asked the providers and healthcare regulators to agree that they would not take action against individuals such as staff members or registered healthcare professionals in certain limited circumstances relating only to their provision of information to the inquiry or their failure to have come forward to provide it in the past. The inquiry has engaged in protracted discussions with the relevant providers and healthcare regulators on this issue. However, almost all, including the largest providers, have declined to give such undertakings. We have been reflecting on what further steps should be taken. We would be interested in the views of core participants and key stakeholders as to whether the inquiry should continue to pursue these undertakings. This is in circumstances where we are seeking to remove what we consider are, for some, bars to coming forward and providing full and frank information to assist the inquiry to get to the bottom of what was going on. I'd like to be clear that the inquiry has not asked for an undertaking from the Attorney General, as is sometimes done in public inquiries, that an individual will not be prosecuted if their evidence reveals criminal wrongdoing on their part. That kind of undertaking is designed to govern the future use of inquiry evidence in criminal proceedings For example, an undertaking from the Attorney General may say that no evidence given to the inquiry by a person will be used against that person in criminal proceedings. The inquiry is not seeking an undertaking that would prevent information provided by a witness to the inquiry later being used against them in criminal proceedings. Similarly, the inquiry is not seeking an undertaking that would prevent information provided by a witness to the inquiry later being used against that witness in regulatory or disciplinary proceedings if that evidence revealed potential wrongdoing beyond their disclosure of confidential information to the inquiry or their failure to report matters at an earlier stage. Put shortly, the undertakings sought would not prevent misconduct proceedings being brought concerning many serious allegations at the heart of this inquiry. Ultimately, the undertaking sought may, we suggest, be key to obtaining relevant information as to what was actually happening in inpatient settings and are proportionate to the circumstances of this inquiry. Turning now to the subject of evidence and how evidence will work at this inquiry. I mentioned at the start of our first hearing last year the process the inquiry uses for obtaining information and documentation. In short, the Inquiry Rules 2006 cover in Rule 9 the process by which the inquiry should seek evidence. This is initially by way of a written request. Those requests go out in the form of a letter. Some organisations, such as EPUT, have received multiple requests for information, which for ease of reference are numbered sequentially, as Rule 9.1, 9.2, etc. This is relevant because you will be hearing about some of these specific requests during this hearing. The inquiry expects that those asked to provide documents or to come to give evidence will do so voluntarily, following the Rule 9 procedure. However, where that does not happen, Chair, you have powers under Section 21 of the Inquiries Act 2005 by notice to require a person to give evidence and to produce documents and materials to the inquiry. It is a criminal offence under Section 35 to fail without reasonable excuse to do anything that is required by a Section 21 notice. It is also a criminal offence to suppress, conceal, alter or destroy relevant evidence. You have made it clear, Chair, that you will use your full powers to secure evidence for this inquiry as appropriate. And I'll say a little bit more about this later. Up to last month, the inquiry had sent a total of 293 requests for information under either Rule 9 or Section 21. These requests were directed to a range of individuals and organisations, including 58 requests to organisations which are core participants, 72 requests to organisations which are not core participants, and 162 requests to individuals and families. Further information can be found in the inquiry's disclosure updates on its website, and the first update was issued last month. As the update records, the inquiry's information requests have focused on a broad range of critical issues affecting mental health inpatient services, which include but aren't limited to inpatient care and safety, the provision and oversight of mental health services in Essex and other areas, including pre-admission assessments, inpatient pathway and incidents of harm, patient monitoring and autonomy. A key area of focus is the use of Oxyvision, which I've just mentioned. Autism and mental health inpatients. The intersection of autism and inpatient mental health care, including the impact of neurodiversity alongside mental health conditions and the adequacy of adjustments made to care. Regulatory oversight and accountability. The role of organisations such as the Care Quality Commission, or CQC, the Nursing and Midwifery Council, or NMC, the General Medical Council, or GMC, the Health and Care Professions Council, or HCPC, National Health Service England, and the Parliamentary and Health Service Ombudsman, PHSO, in monitoring mental health inpatient services, responding to incidents, and addressing concerns raised by patients, families, and staff. And I'll be coming on to talk a little bit more about that later. Investigations into serious incidents, the examination of whistleblowing reports, safety incidents, including physical and sexual safety, ligature and absconsion data, as well as official investigations undertaken by Essex Police and prosecutions by the Health and Safety Executive. And staff and staffing matters, the examination of the approach to staffing, training and working conditions for those providing inpatient mental health care. This includes staff support and supervision, as well as evidence relating to staff-related concerns and experience shared by individuals. As I've said, some of the evidence to which I've just referred will be considered at this hearing. I'm now going to ask Amanda to put up the March 2025 disclosure update and to go to the annex here, please, at the end. Thank you very much. And by looking at the update, we can see from it the wide range of organisations that have been contacted. They're listed alphabetically and from Autism Action. And could you just scroll down, please, to the bottom? To West London NHS Trust there, and including many in between, including both OxyHealth and Stop Oxyvision. Could you take that down, please? That disclosure is in addition to the important information that was obtained during the non-statutory phase of this inquiry, when it was the Essex Mental Health Independent Inquiry. This includes, for instance, transcripts and recordings of evidence sessions with family members and others. That information has been reviewed and will be incorporated as appropriate into the statutory inquiry. As I've previously mentioned, in many cases, members of the inquiry team are working with families who attended evidence sessions with the non-statutory inquiry to use the transcripts of those sessions to form the basis of their witness statements to this inquiry. During February and March, the inquiry received thousands more documents in readiness for this April hearing. The inquiry intends to publish disclosure updates periodically, with the next one being in June 2025, ahead of a hearing in July. The inquiry appreciates the engagement of all the organisations that have worked hard to make full and timely disclosure. Work is ongoing regarding future requests, which will extend beyond the themes currently highlighted and which will continue to be relevant to the terms of reference and matters in the list of issues. As I mentioned, certain organisations and individuals have received multiple Rule 9 requests, reflecting the complexity and breadth of the inquiry's investigations. In instances where responses have not been forthcoming or do not include sufficient detail, and the information is deemed critical to the inquiry's progress, Section 21 notices have been issued to compel the submission of evidence. This underscores the inquiry's determination to obtain the necessary information to fulfil its terms of reference. Some healthcare providers and indeed other organisations have so far expressed difficulty in making the full disclosure the inquiry has requested. They have suggested to the inquiry that they are experiencing various problems, which broadly include that earlier records were created as paper documents that have not been kept in good order and take time to access and review. Electronic documents are held in different places and in poor order. Documents, both paper and electronic, are missing because physical locations have since closed down or private health organisations have changed hands. Identities in certain documents should not be disclosed to the inquiry for privacy and data protection reasons, and that the inquiry has not given the organisations sufficient time to make the relevant disclosure. As we have previously said, the inquiry has repeatedly been told that records and documentation relating to the earlier stages covered by the inquiry, and our terms of reference go back to the start of 2000, will be more difficult to obtain and will be scarcer. The inquiry has concerns arising from the reasons given by some organisations for failure to make relevant disclosure. We have been unimpressed with the significant number of requests for deadline extensions, the number of late disclosures, and the number of occasions where providers have not given the inquiry the material it has expressly asked for. Where we have felt it appropriate, we have worked with those providing documents who have reasonably sought further time or information about what they should be providing to the inquiry. We recognise and appreciate that many providers have made every effort to comply. Unfortunately, in too many instances, reasonable disclosure requests from the inquiry were not fully complied with or came late, sometimes very late. We expect providers to address now any teething problems that they have encountered. We have indicated that we also expect them to be properly resourced to engage with the inquiry and to make timely disclosure. As I mentioned, in certain instances, Chair, you have felt it necessary to rely on the powers you have by virtue of this now being a statutory inquiry. Some providers have been issued with Section 21 notices to compel the production of documents and information. For example, in one case, a notice was issued to the private provider Nest. This was because of an inexcusable delay in providing evidence we had requested. That evidence has now been handed over to us. One provider and one regulatory body proactively requested the issuance of Section 21 notices to facilitate their own internal processes and to ensure compliance with legal procedural requirements in respect of particular categories of evidence. In those circumstances, the issue of the notice does not reflect a failure by those organisations. The inquiry will continue to use its statutory powers as necessary to obtain the information requested to ensure a full and transparent examination of the issues under consideration. And I make it clear now that the future work of the inquiry, including its future hearings, must not be delayed because of disclosure failures by providers or others. With good reason, the inquiry, the families, those with lived experience, and the public would not tolerate that. Moving now to a new topic. The inquiry has been reviewing its procedures to ensure it's able to obtain best evidence from those involved. The inquiry is working to ensure its processes take account of the trauma suffered by those who are participating and seeks advice from its chief psychologist in that regard. The inquiry has also extended assistance to legal representatives in the form of a trauma-informed awareness session. Chair, you have already indicated that the inquiry will not force any family member or person with lived experience to provide evidence to the inquiry. Moreover, you have granted anonymity, or are minded to do so, to all persons with lived experience of mental health inpatient services. The inquiry has updated various protocols. This is with the aim of assisting those who wish to engage with the inquiry in providing the best possible evidence in a way that ensures they are supported throughout the process. These include the protocols for the April hearing on restriction orders, redaction, anonymity and special measures, on vulnerable witnesses and on witness statements. We have already recently amended some of these protocols For example, the protocol on restriction orders, redaction, anonymity and special measures has been amended to clarify the inquiry's approach to special measures and their interaction with restriction orders. Chair, you have a wide discretion to put in place measures to support witnesses giving evidence. We will take an individualised approach as far as is reasonably possible. The inquiry also offers emotional support to all engaging with it. The inquiry is liaising currently with core participants with lived experience about how the inquiry is going to take their evidence. We intend to finalise the lived experience framework after this April hearing has concluded. I would now like to provide an update on the work that has been done to identify the deaths in scope of the inquiry's terms of reference. Since the hearings in September and November last year, the inquiry has developed a deeper understanding of the scale of the challenges involved in this work. This has come through careful consultation with providers and core participants and with input from the inquiry's independent assessors. As you emphasised in September, Chair, the terms of reference and inquiry's definition of inpatient death are broader than those of the non-statutory inquiry. They include those who were assessed but not admitted to inpatient care. This element in particular significantly increases the complexity of the work required to identify all relevant deaths. During the time frame of the inquiry, the vast majority of mental health care was delivered in the community. So the number of those who were assessed but not admitted is potentially extremely large. The inquiry has had to make some careful decisions to ensure that its investigations properly include deaths that occurred soon after an inpatient admission would or should have been considered, without distorting the necessary focus of the inquiry on inpatient deaths. These issues have led the inquiry to clarify its scope. Chair, last year you provided an explanatory note along with the amended terms of reference, and I'm going to ask now, please, for the amended explanatory note to be put up. Could you highlight the top, please? Or expand the top. Oh, not to worry. If you expand that, please. As you can see, the slightly longer title of this document is Explanatory Note in relation to scope. Would you reduce the expansion, please? And as you can see just under the title, it makes clear that it does not form part of the terms of reference, but indicates how the Chair is minded to interpret them. And Amanda, would you mind expanding from the inquiry's definition of inpatient death down to the bottom of the page, please? As we can see here, from A to F, and at the top of the next page, would you just expand that, please, G and H? Chair, you've set out how you intend to define inpatient death. I'm just going to read out G. Those who died within 3 months of a mental health assessment provided by the trusts or on behalf of the Essex local authorities, which did not result in admission as an inpatient. This will be primarily focused on assessments in A&E and initial assessments by crisis teams or other teams with a gatekeeping role over inpatient admissions, as well as assessments under the Mental Health Act, but may include other cases at the Chair's discretion. You have now clarified the entry at G in this amended version of the explanatory note that was provided on the 10th of April. The definition at G now emphasises that the inquiry's primary focus is on the mental health assessments which are most closely connected to inpatient admissions. The main change is in the second sentence. The new wording identifies the focus by naming the relevant assessment types. They are those occurring in A&E, those undertaken by crisis teams or other teams with a gatekeeping role over inpatient admissions, and those which take place under the Mental Health Act. Incidentally, earlier in the text of G, there is a new reference to local authorities. You can see it on the second line. To recognise the statutory responsibility they hold for the Mental Health Act assessments, we now understand that these can take place without the involvement of the trusts. Returning to the second sentence, the phrase initial assessment is used in relation to the crisis teams to make clear that it makes the assessment undertaken after a new referral is made to a crisis team. This is rather than the repeated ongoing assessments which may take place under home treatment. It's not just the number of deaths in scope that is important, although that is very important. It is also the information obtained about those deaths will need to enable reliable and robust findings to be made about the themes and patterns revealed by the data. This includes, for example, conclusions about the proportions of deaths which were or may have been preventable. Could you take that down now, please? We also now have the assistance of the inquiry's expert health statistician, Professor Donnelly. She has begun work analysing the information about those who have died. Once that initial work is complete, Professor Donnelly's guidance will be sought on how best to optimise the data provided. This will strengthen the conclusions that can be drawn from the data and which will facilitate comparison with other parts of the country, bolstering the weight of the findings and recommendations that are made. It will be clear from what I've just said that we do not yet have a number for the deaths that come within the scope of this inquiry. The inquiry is keenly aware of the interest in that number. We will provide the most accurate number that we can when we have, with expert assistance, collected the data we need and analysed it appropriately. Could you put up the explanatory note first page again, please? And thank you, yes, expand there. While we're looking at the explanatory note, can we stay with the definition of inpatient death and look at A? And we can see it says those who died on an NHS mental health inpatient unit or in receipt of NHS-funded inpatient care within the independent sector, whether detained under scrutiny or informally. Units within scope include adult mental health units, psychiatric intensive care units, or PICU, CAMS units, child and adolescent mental health services units, acute and PICO, mental health assessment units, mother and baby mental health units, older adult mental health units, eating disorder units, forensic or secure units, learning disability units, and drug and alcohol units. Chair, you've decided to amend this part of the definition. The section lists the types of mental health units which are included within the scope of the inquiry's investigations. However, the previous wording suggested that the list was exhaustive. This led some providers to conclude that some types of units which were not named, such as learning disability units and drug alcohol units, were not to be considered. Later in the explanatory note, learning disabilities and drug and alcohol addiction are included amongst the particular circumstances that you will consider during your investigations. It would be anomalous and inappropriate to omit the mental health care that individuals in those circumstances received within units dedicated to the management of those issues. Therefore, Section A has been amended, as you can see the last two bullet points, to add learning disability units and drug and alcohol units to the list. The wording above the list has been changed to units within scope include, in order to clarify that the list should not be considered exhaustive. The former wording was units to be included are. Would you take that down, please? Thank you. Before I leave the topic of the explanatory note, I'd like to say this. I've talked a lot about statistics. As an investigative progress, we of course have to look at the figures in an analytical and objective way in order to see trends, spot issues, and make findings. However, we recognise that behind the staggering figures, each death was of a person with their own life and their own individual circumstances that led them there. And Chair, I'd like to use that moment to break for an hour, so that means we will reconvene at 1:30, please.
1:30.